Hi, my name is Andrew Kinney. I'm an attorney. I practice in the area of Social Security disability law and SSI law for disabilitylawyer.com. I've been doing this work about 20 years. And today I want to talk to you in this video about vocational experts, VEs for short. The VEs are traditionally used at Social Security hearings, and they have since the inception of the program to some degree or another. At least in the last 20 years, in every hearing that I have, almost every hearing has a vocational expert. Well, who are these people? Vocational experts are people that are trained as rehab counselors or have some degree in vocational training such that they can give advice about the marketplace and what jobs exist. Now, Social Security will generally hire these vocational experts on a contract, and although they're paid by Social Security, they are to be independent and give independent advice at Social Security hearings. So, when do you see a VE? Well, if you have a Social Security claim that's at application denied, reconsideration denied, roughly about 2 years in, let's say, maybe a year and a half into your Social Security claim, you would get to a hearing and your attorney would be sitting with you. Over on the other side of the hearing room would be a vocational expert. They generally do not interact with you. They may during the hearing a little bit, but their main job is to answer questions from the judge. What kinds of questions? Well, the Social Security Administrative Law judge, after the judge understands from you what your limitations are in your own words, and perhaps getting some input from a medical expert, will then turn to the vocational expert. The question of the day generally is this: with the limitations that you have that are proven in the record, could you hold a full-time job? That's the question of the day. The job expert will have an answer based on having perhaps carpal tunnel syndrome bilaterally and having some neuropathy of your toes and maybe having difficulty with the cervical spine. Whatever combinations you have, perhaps you have trouble concentrating with depression. The combined problems may or may not limit you in your ability to do any work at all. The job expert will cite jobs that in theory could deny you. So the job expert's role is laying out, based on limitations before him or her, are there jobs that exist that in theory you could do. They don't care if you can get to the jobs. They don't care if the jobs pay enough. Social Security doesn't care if the job market is bad. All Social Security cares about is, in theory, are there enough jobs that you could do? What your response is this: you have an attorney next to you that will follow up with questions for the vocational expert, specifically with cross-examination. Your attorney needs to ask about the foundation of these questions. Your attorney also needs to add to the limitations or clarify the limitations, or sometimes a very basic thing, clarify the definitions that are being used. How did the vocational expert understand the judge's question? In the end, your attorney should have experience not only with the vocational experts, but with Social Security law in general. The goal is this: you just need to make sure the hearing's fair. You need to make sure that the judge hears the limitations that are reasonably related to the record and that your attorney can anchor them or tell the judge where in the record do you get that information, because the questions your attorney asks may result in no jobs at your hearing. If the judge agrees with your attorney's limitations, you can be approved for benefits. It could be that important. So make sure with the vocational experts that you have someone by your side to follow up with anything the vocational expert testifies to. If you have more questions about vocational experts, experts in general, or just the Social Security disability process, please feel free to call us. That's why we're here at disabilitylawyer.com. Thank you.